Welcome back. Now, Justice and Correctional Services Minister Ronald Lamola wants apartheid-era laws reviewed, repealed and replaced. He says they've contributed to high prison numbers. Lamola also believes these laws don't fit into a constitutional democracy. Now, on Monday, Minister Lamola gave an overview of the department's annual performance plans. And joining me now to unpack this is legal expert Ulrich Roux. Ulrich, thank you so much for your time. Let's just get clarity here. I mean, the two acts with which the minister refers to here, I understand, is the Criminal Procedure Act as well as the Correctional Services Act. What does the minister particularly find problematic about these two acts?
Well, I think if you read between the lines of what the minister says, he claims that both acts came into being during the apartheid era, the 1970s to be exact, and that they therefore cater for apartheid-era regime and governance. I think, you know, what he is saying is that if the act were to be amended, we would be seeing less people incarcerated and subsequently jailed because of the act being more in line with the Constitution. So both acts initially came into being prior to the South African Constitution of 1994 being adopted, and accordingly he says that they are no longer in line with the provisions as set up in the Constitution.
But this is not the first time that this particular act has been amended, or rather proposed to be amended, particularly this Criminal Procedure Act of 1977. It's previously been seen, or rather seen more amendments, right, over the decades.
Yes, no, definitely. The act came into being in 1977, and it has, of course, been amended on numerous occasions since it came into being. As our laws change and as society changes, and you see the prevalence of certain cases coming up more and certain cases, sort of diminishing as time goes by, the Act has been amended accordingly. So the Act constantly changes, and that is how our law works as well. It changes with the times. But on the other hand, the minister does make a strong argument in that it was brought into being long before the Constitution, so accordingly it must be amended and changed to be in line with the Constitution. He has not been specific as to what provisions exactly need to be brought in line with the Constitution, so we'll have to wait and see what he does. There's obviously an extensive process which he will need to follow in order to bring a new act into being, and we'll have to wait and see where they actually proceed with that.
I mean, we heard that the minister speaking of how the particular acts have been sort of catering for a different society then, which is different from today. But when we speak of, legislation amendments, Ulrich, I mean, how long does this particular or rather kind of amendment usually take?
No, it does take long. So a minister will have to present an amendment to the National Assembly. The National Assembly will then consider it. It will be opened up to the public to provide commentary as well. And only subsequent to that will it then be finally accepted or rejected by the National Assembly. If it is accepted by the National Assembly, then the President, of course, needs to sign it into being, and it is then gazetted, which means that it is then law. To change a law does take a considerable amount of time, but it can also be fast-tracked. We've seen now with, for example, the Disaster Management Act, that was amended quickly because it needed to be amended quickly as a result of the entire world facing a global pandemic. But normally it does take months. It could even take up to years before a new act is brought into being.
And this decision or the proposal by the minister, could it possibly have us seeing more of a domino effect on other acts or even legislation being amended or at least being proposed for amendment? I mean, the minister does refer to these laws as apartheid-era laws.
Yes, certainly. Remember that the Constitution is our apex law in South Africa, and any other act which is not in line with the Constitution is seen to be unconstitutional and accordingly invalid. Again, as I said earlier, he does have a point in that all the acts which were brought into being prior to our Constitution being adopted in our country can be seen to have been adopted by an apartheid regime or whichever regime was in charge at the time that the Act was adopted. But that is why there is an opportunity to have acts amended to bring them in line with post-constitution regulations. Certainly, if you had to change all the acts and brought new acts into being for all of our laws in the country, it would be an administrative nightmare and a mammoth task to do that. So I think that is, it's a bit far-fetched to think that all acts must be amended and changed. But certainly, if he feels that anything contained in the Criminal Procedure Act and the Justice Administration Act is not in line with the Constitution, he must change it.
Well, thank you so much, Ulrich Roux, legal expert there, joining us, talking about Minister Ronald Lamola, of course, tabling in Parliament that he would like, of course, apartheid-era laws, particularly the different laws, namely the Criminal Procedure Act, as well as the Correctional Services Act, of course, being repealed and replaced.